She ran. The former First Lady of the United States, the woman who stood in the Rose Garden and smiled for the cameras, the woman who wore designer gowns at state dinners, the woman who told American children to be best. She ran from a federal judge, not a political attack, not a press conference ambush, a lawful court order signed by a judge, backed by the full authority of the American legal system. And Melania Trump looked at that order and left the country at 6:47 in the morning, before her own lawyer even knew the postponement request had been denied, before the court had ruled, before anyone could stop her. And right now, as you watch this video, the United States Secret Service is refusing to tell a federal judge where she is. Read that sentence again. The Secret Service, a federal agency paid by your tax dollars, is defying a court order to hide the location of a woman with an active arrest warrant. This is not a reality show. This is not political theater. This is a constitutional crisis unfolding in real time. And in the next 15 minutes, I am going to walk you through every document, every timeline, every signature, every shell company, every lie told to a federal judge, because the 41-page arrest warrant tells a story that nobody in mainstream media is telling you completely. Stay with me, because this gets darker with every page. Let us start at the beginning, because context is everything. 8 months ago, New York Attorney General Leticia James expanded her investigation of the Trump Organization to include transfers made during the 2024 presidential campaign. What her forensic accountants found stopped them cold. $38 million, $38.4 million to be precise, moved across 23 separate wire transfers, all sent to shell companies with no employees, no websites, no disclosed services, and no legitimate business purpose. And on every single authorization form, Melania Trump's signature. Not a staff member's signature, not a lawyer's signature, hers, 23 times across 17 months. 5 months ago, investigators formally traced those signatures back to accounts nobody even knew she controlled. 3 months ago, Judge Paul ordered Melania to appear for a deposition to explain those transfers. She requested a delay. The judge granted it. Extended patience, professional courtesy, new deadline, May 21st, 2026. That should have been the end of the drama. It was just the beginning. Before we get to the escape, let us talk about what she was being asked to explain. Because this is not about one suspicious transaction. This is about a pattern, documented, time-stamped, signed, June 2024. First transfer, $2.1 million, sent to Adriatic Consulting, LLC. What does Adriatic Consulting do? Nobody knows. No employees, no website, no services ever disclosed. Registered in Delaware specifically to minimize disclosure requirements. August 2024. 5 separate transfers. Total $8.7 million. Sent to 3 different entities. Same profile, no employees, no services, no explanation. October 2024. Final transfer before the election. $4.2 million. Sent 3 days before Americans went to vote. 3 days. And the shell companies receiving these funds: Adriatic Consulting, Mediterranean Holdings, LLC, Alpine Strategic Group, all 3 were created within 45 days of the first transfer. They were not pre-existing businesses. They were created specifically and rapidly right before the money started moving. Judge Paul's conclusion on page 33 of the arrest warrant is unambiguous. The pattern indicates intentional concealment rather than administrative oversight. That is arrest warrant language. That is a federal judge saying, "This looks deliberate." And Melania Trump's signature appears on every single authorization, 23 times, across 17 months. The defense of "I did not know what I was signing" dies on page 1 of Exhibit G. Now let us talk about what happened before the warrant was issued. Because this judge did not act impulsively, he gave her every possible opportunity to comply. Page 14 of the arrest warrant documents exactly what happened. Secret Service logs show 6 certified notices delivered to Melania's legal team. 6. April 23rd. First notice, documented delivery confirmed. May 1st. Second notice, confirmed. May 8th. Third notice, confirmed. May 15th. Fourth notice, confirmed. May 19th. Fifth notice, confirmed. May 20th. Sixth notice, the day before the deadline, confirmed. And page 19 goes further. Phone records show her attorney spoke with her directly on May 19th, yesterday, about today's appearance. And here is the devastating part. Defendant confirmed awareness of May 21st deadline in recorded call. She knew, it is documented, it is recorded, it is on page 19. This is not a woman who forgot her court date. This is not a scheduling mix-up. This is a woman who knew exactly when she had to appear, confirmed it verbally the day before, and then chose not to show up. That choice has a name in American law. It is called willful contempt. If you are watching this and nobody in your circle is talking about it, subscribe right now. Share this video immediately, because the algorithm buries what power does not want you to see, and what you are about to hear next is worse than everything you have heard so far. Now we get to the part that transforms this from contempt of court into something far more serious. The escape. Page 27 of the arrest warrant. Mar-a-Lago security footage, reviewed by court investigators, shows Melania's motorcade departing Tuesday at 6:47 in the morning. Tuesday. 2 days before the Thursday deadline. Destination, a private airstrip. Flight plan filed to Bedminster, New Jersey, outside Judge Paul's jurisdiction. She was gone before most people had finished their morning coffee. But here is what makes this premeditated rather than impulsive. Look at the timeline carefully. Tuesday 6:47 a.m. Melania departs Mar-a-Lago. Tuesday 9:23 a.m. Her attorney, Michael Howerin, files an emergency motion requesting postponement of Thursday's deposition. Tuesday 11:15 a.m. Judge Paul denies the postponement. 2 hours and 28 minutes between her departure and the denial. She left before she even knew if the delay would be granted. She did not wait for the judge's decision. She did not wait to see if her lawyer's motion would succeed. She packed up and left before the legal process had even played out. Former federal prosecutor Sarah Chen confirmed exactly what that means. Leaving before the postponement decision shows contempt was intentional, not reactive. She never intended to appear, regardless of what the court decided, and the excuse her lawyer gave for the postponement? A prior commitment to a charitable foundation event in Europe, scheduled months ago, impossible to reschedule. Judge Paul's investigators checked. Page 39, footnote 7. Court investigation found no evidence of claimed charitable event. Counsel's representation appears materially false. The excuse was fabricated. There was no event. Her lawyer lied to a federal judge, which means this is no longer just about Melania. Her attorney is now facing potential sanctions for making a materially false representation to the court. Contempt plus obstruction. 2 people in legal jeopardy instead of 1. Thursday, May 21st, 12 noon. Courtroom 506, New York State Supreme Court. Judge Paul takes the bench. Melania's legal team arrives. 2 attorneys, no defendant. Judge Paul asks the question everyone in the room is thinking. Where is Mrs. Trump? Lead counsel Michael Howerin responds, Your Honor, we have been unable to reach our client since yesterday evening. The judge's next question cuts through the room like a blade. Did you know her location before today? Howerin's answer, we believe she is in New Jersey but cannot confirm. Judge Paul's response at 12:08 p.m., belief is insufficient. Your client was ordered to appear. What followed was the fastest legal escalation in this case. 12:11 p.m. Judge Paul issues bench warrant. 12:43 p.m. U.S. Marshal Service receives enforcement order. 2:17 p.m. Full arrest warrant with jurisdiction expansion filed publicly. 2 hours and 6 minutes from missing defendant to active arrest warrant. But Judge Paul was not finished. Simultaneously, while issuing the arrest warrant, he issued an emergency asset freeze order on 7 Trump Organization accounts. Docket entry 847-B, filed at 2:19 p.m. Emergency financial preservation prevents transfer of funds during contempt status. He froze the money because this is no longer just about a missed deposition. This is now about protecting the evidence. And now we reach the moment that changes everything. The moment that transforms a contempt case into a constitutional crisis. Judge Paul needed to know where Melania was, so he asked the one agency that always knows exactly where she is, the United States Secret Service. Their response? We have maintained our protective detail, but will not disclose her location without a court order. A federal agency, funded by your taxes, protecting someone from a lawful arrest warrant. Judge Paul did not hesitate. His 4:47 p.m. order was direct and unprecedented. Secret Service must disclose location within 24 hours or face their own contempt proceedings. A federal judge threatening to hold a federal security agency in contempt of court. Constitutional law professor Lawrence Tribe said what everyone was thinking. There is no precedent for Secret Service defying a court order to protect a former First Lady from a contempt warrant. And conservative legal analyst Jonathan Turley, not exactly a Trump critic, acknowledged the gravity. If Secret Service refuses location disclosure, a constitutional crisis is possible. When legal voices from opposite ends of the spectrum agree on the word crisis, you are in a crisis. This is the breakdown that 41 pages of court documents demanded. Subscribe, turn on notifications, share this right now, because Friday at 5 p.m. everything changes, and you need to be here when it does. After the warrant dropped, 3 camps responded, and each response told you everything about where this is going. Melania's spokesperson released a statement at 4:23 p.m. through email, not a press conference, no attorney present. Quote, "This is persecution of a private citizen who has cooperated fully." Cooperated fully. Those 2 words. Page 22 of the arrest warrant lists 4 separate documented instances of non-compliance. February 12th, failed to produce financial documents. March 8th, skipped a voluntary interview. April 3rd, ignored a subpoena for financial records. May 21st, fled jurisdiction before court-ordered deposition. That is not cooperation. That is a pattern of escalating defiance across 4 separate court orders. Then came Donald Trump. 47 posts on Truth Social in 90 minutes. 47. He called Judge Paul a corrupt partisan hack. He called the case a witch hunt. He called Melania an innocent victim of political persecution. What he did not post, not once across 47 posts, was where she is, was that she is cooperating, was that she will appear voluntarily. Nothing about resolution, nothing about compliance, only attacks on the judge. And Judge Paul responded the next morning with something he almost never uses, a gag order on all parties and their counsel regarding case details, because Trump's posts were not just political noise. They were strengthening the obstruction case, showing a pattern of contempt for the judicial process. Every attack on the judge is now evidence. They came to fight, and the judge came prepared.